Hello, my name is John Milburn, and today I'm reviewing Chapter 9 of Jerry Bates' book, Environmental Law in Australia. This chapter deals with environmental assessment of projects and activities and also development control. We've in the past talked about the separation of powers and the role of the executive in environmental law. The executive, through its administrative function, plays a vital role in the operation of environmental law. Government and local government licensing of projects and activities that are likely to have environmental impacts is the cornerstone of environmental management and therefore of environmental law. In Chapter 9, Jerry Bates does discuss the relevance of the impact of environmental impact of a proposed development when the application for development consent comes before an assessment manager. This chapter is all about assessing the environmental impacts of development in considering applications for development consent under environmental planning legislation. The objectives set out in environmental planning instruments set the ground rules for development control. And you recall we talked about what we mean by environmental planning instruments earlier in the course. So, the environmental planning instruments establish the ground rules, and environmental plans or management plans deal with more specific detail relevant to a particular application. The objectives of environmental management plans constrain the exploitation and use of natural resources. So what's this chapter all about? In this chapter, we consider 5 major topics. The first is development control in environmental planning legislation. The second is assessing the environmental impacts of development. The third is planning agreements. The fourth is fast-tracking major projects. And finally, we talk about appeals. So let's talk about the first of those issues, and that is development control through environmental planning legislation. It is generally an offence, of course, to carry out development without consent where consent is required. But the preliminary question is, what is development? And development is commonly defined in planning legislation as encompassing building and other work on land, a change of use of land, demolition and subdivision, and may include other types of activities. So it's important to appreciate that when we talk about development, we're not just talking about construction. It may include material change of use of land or activities that does not involve any construction or operation whatsoever. When we talk about a material change of use of the land, we're talking about the zoning use, the appropriate zoning use, which is substantially different to what was previously the case. So how do we determine whether a proposed activity is regarded as development, and if so, what guidelines need to be fulfilled to successfully apply for consent to develop? As you might expect, first we look at the overarching legislation. So firstly, we look at the state environmental planning instruments as the first place to look to determine whether this is development and what guidelines need to be applied to obtain consent to develop. So consideration of applications for development must take place within the framework set out in those environmental planning instruments. So what is the test? Does the application have to be compatible with state-level planning instruments and subordinate instruments, such as local environmental plans? In general, it may be said that the state environmental planning instruments provide guidance and flexibility regarding the achievement of statewide planning objectives and do not create inflexible regimes of control. For example, where a local environmental plan required that a development consent be consistent with the objectives of the plan, This did not require a positive finding of compatibility. Rather, it meant not incompatible or inconsistent. So we can see from that when it comes to assessing applications to develop, it's not a matter of interpreting the state level planning instruments in the way that we might other pieces of legislation. It's more relaxed than that. There's more flexibility, and the instruments provide guidance, but not absolute necessity in terms of a positive finding of compatibility. So then, how do we go about interpreting planning instruments? What is the test? A very good guide is given through the words of Justice Talbot, who in Katoomba Gospel Trust against Blue Mountain City Council from 1993, 130 LGERA 266 said, "Planning instruments should not be interpreted as if they were statutes. They should be interpreted with the intent of providing a practical outcome consistent with a reasonable interpretation using a common sense approach." Now that we have considered the overarching approach to be adopted, let's consider development control in more detail. What is the general scheme adopted by Parliament to give guidance as to development control? How does Parliament intend administrators to control development applications? The starting point is to note that development means a good number of things, as we discussed. It might include subdivision or construction. Before we can consider what control is to be applied by the local authority in determining a development proposal, we need to remember that development, irrespective of the type of development, may be classified in a number of different ways. Under relevant planning schemes, development may be classified variously as permitted, development that does not need consent or is exempt, complying development, prohibited development, or development that does need consent. So development means a great number of different things. In Queensland, we first look at the Sustainable Planning Act 2009 for guidance. In that Act, you'll recall that the Integrated Development Assessment System, IDAS, which was dealt with in Chapter 6 of the Sustainable Planning Act, provides some guidance and refer to sections 230 to 234. Section 231 of the Act provides that all development is exempt unless it falls into a category that requires an assessment. Then we note that a development permit is only required for accessible development, and that's sections 235 through to 238. So, in Queensland, all development is exempt unless it falls into a category that requires assessment, and a development permit is only required where that development is accessible development. So before a development can proceed, applications may need to be referred to other government agencies, either for concurrence with the development proposal or advice in relation to it. Concurrence agencies are really agencies which provide relevant input to the proposal, and it's all part of this IDAS system where there's a centralisation of control of the consideration of the proposal. It leads to greater efficiency. So many proposals for development will also require the issue of licences for other aspects of proposal. For example, in addition to development consent, a development proposal may need separate licences to clear native vegetation, affect threatened species, emit pollution, or impact on heritage areas. So effectively, in those circumstances, these other licensing agencies as concurrence agencies may therefore be able to veto a proposal by refusing to issue a licence for aspects of proposal controlled by them. If the proposal is one which the permitted authority does have power to refuse, the authority will generally be required to advertise the application, and after due consideration of any public submissions prompted by the advertisement, make a decision whether the permit to develop with conditions should be given or whether it should be refused. I mentioned that there are requirements to advertise, and failure to comply with the public notice procedures may result in the process being declared illegal or invalid rather. All right, so that's our first topic in Chapter 9, which deals with the whole issue of development control in environmental planning legislation. Now let's look at the second topic of the 5 that I identified, which is assessing the environmental impacts of development. In making a decision about an application for development consent, environmental factors are of prime concern. Applications for development consent must contain prescribed information that includes assessment of projected environmental impacts. Proposals that are likely to involve significant environmental effects may be required to undergo a formal process of environmental impact assessment, EIA, and this is discussed in Chapter 10. Also, have a look at the commentary by Phil Jeston, a scientific expert in the area, and there's a separate Zoom session for you to look at in that regard. So let's look at the position in Queensland. As indicated before, in Queensland, all development is exempt development unless it's accessible, self-assessable or prohibited, or development requiring compliance assessment. And as we mentioned before, a development permit is only necessary for accessible development. A compliance permit is required for development requiring compliance assessment. And this is all part of that IDAS system. So let's talk a little more about IDAS, the Integrated Development Assessment System. As mentioned, it has several stages: the application stage, the information and referral stage, the notification stage, the decision stage, and the compliance stage. That's 5. Not all parts of every stage will apply to every development application. So a development application may be accessible, but what is accessible development? A regulation may require impact or code assessment, or both impact and code assessment, for this accessible development. So what do these terms mean? Well, firstly, in the context of an accessible development, I've mentioned that the regulations may require the impact assessment or the code assessment, or maybe both. Code assessment means that the assessment of the development by the assessment manager, usually council, or any referral agency is considered against the purposes which are referred to in the instrument containing the applicable code. So that's why we call it a code assessment. An impact assessment means the assessment of the environmental effects of the proposed development and the ways of dealing with those. So that is the way in which the assessment of the environmental impacts of a development are dealt with in general terms, specifically in Queensland, and in that regard, have a look at the IDAS procedures. Let's move on to the third area, which relates to planning agreements. Now, just a brief comment about this. A planning agreement is a voluntary agreement which is concluded between a developer and the consent authority, under which the developer may agree to provide material public benefits or even pay money or contributions for public purposes, or otherwise achieve or advance the purposes of the planning regime. So planning agreements should not be ignored. They're an opportunity to provide some great flexibility in terms of the way in which a development application is considered. The fourth issue is to do with fast tracking of proposals, and this relates to major projects. So fast track is a legislative device to provide a streamlined approval process for developments. In Queensland, under the State Development and Public Works Organisation Act of 1971, significant development may be fast-tracked by having all relevant permit applications referred to the Coordinator General for environmental coordination. The Queensland Government's assessment of importance of tourism to the Queensland economy led also to the Integrated Resort Development Act of 1987, which provided an accelerated government approval for large-scale private tourist development proposals. You may recall in the 80s considerable controversy in that regard. In Queensland, in addition to the powers of the Coordinator General referred to previously, the Minister may give directions to assessment managers about matters of state interest. They may call upon for an issue of the development that affects state interest to be considered, and the Minister may then become the consent authority. So the Minister steps into the shoes, as it were, in those particular instances. Another way for government to facilitate major development projects is by persuading Parliament to enact special legislation for those projects. Just a brief word about indenture or franchise agreements. They're contractual arrangements concluded by the government and a proponent of a major development, and they're given force of law by a special act of Parliament. Now, these techniques are generally used to support multi-$100 million mineral recovery and processing projects, develop timber resources, construct toll roads, and facilitate urban development projects. Our final topic for this chapter, and I'll make just a brief comment, is in relation to appeals. Applicants for development consent and objectors to development applications are often allowed to appeal the decision of planning authorities to specialist courts or tribunals. In Queensland, of course, that's the Planning and Environment Court, which is at the district court level. These are merits appeals. What that means is that the decision of the appeal body is made on the merits of the application in final form. In other words, it's not a review of what was done earlier, it's a hearing of the matter afresh, as it were. It is possible that points of law which arose during the appeal process may be appealed to a court of law as well. So that brings us to the end of Chapter 9. Significant examples of merits appeals are reported in publications such as Environmental Law Reporter and Queensland Environment and Planning Reports, as well as Local Government and Environment Reports of Australia, and all of these things can be accessed through AustLII. Thank you very much for your attendance today. I'll stop recording now.